All right, folks, buckle up because today's case is one for the books. We're diving into a courtroom showdown where an entitled mother, and yes, we're talking full-blown Karen mode here, decided that court orders were merely suggestions. Suggestions she could ignore. Suggestions she could toss in the trash like yesterday's junk mail. This woman has been systematically denying the father of her children his court-ordered parenting time. Not once, not twice. We're talking for separate motions this man has had to file just to see his own daughters. For times he's had to hire an attorney, walk back into a courtroom, and beg a judge to enforce what should have already been happening. And every single time, she just slams the door. Literally, she slams the door in his face. She slams the door in the police officers' faces. She slams the door on the court system itself. But here's where it gets truly unhinged. This woman has made some of the most serious allegations you can possibly make against a parent. Allegations that were investigated by CPS, not once, but TWICE. Investigated by police twice, and every single time. Nothing. Absolutely nothing was substantiated. Zero. And yet she keeps using these debunked allegations as her personal justification to defy the court. She has convinced herself that she is above the law, that she knows better than the judge, better than CPS, better than law enforcement. And today is the day that delusion comes crashing down around her, because this judge has had ENOUGH. By the end of this hearing, Karen isn't just going to lose, she's going to be led out of this courtroom in handcuffs. And spoiler alert, she makes it even worse for herself by running her mouth on the way out. So sit tight, because this one escalates fast and the ending is absolutely Let's get into it. Asterisk.
This time and place set for the show cause hearing in this matter for contempt for failure to provide parenting time. I'll let you know we're going to take some brief, testimony from the parties. I'll let everybody know that everybody will have an opportunity to speak. So don't interrupt anyone else or don't interrupt the court. You'll have an opportunity to speak your piece. So on the we do have the show cause hearing. We also have the motion for change of custody and parenting time. I'm going to address the motion first because that will be the easiest matter to get resolved. So, Mr. Kelly, you can proceed with your motion.
Your Honor, essentially, that motion is based primarily on the issues we've had ongoing in relation to.
Okay, so let me break down what's happening here for those of you who might not be familiar with family court procedures. There are two matters on the docket today. First, there's a motion for change of custody and parenting time. That's the father's attorney asking the court to modify who has primary custody of the children. Second, there's the show cause hearing, which is essentially the court hauling this mother in to explain why she shouldn't be held in contempt for violating court orders. And the judge is being very strategic here by addressing the custody motion first. He's laying the groundwork. He wants to establish the pattern of behavior before he drops the hammer on the contempt charges. Notice how he also gave everyone a very clear warning right out of the gate. Don't interrupt, you'll get your turn. Remember that warning, folks, because it's going to become very important later. The judge already knows this is going to be contentious, and he's setting the rules of engagement early. Now let's listen to the father's attorney lay out the case. And pay close attention because the legal factors he's about to walk through paint an absolutely devastating picture of this mother's behavior.
Compliance with the court order and my client getting parenting time. It's directly and impacts the child custody factors, and I'll name the ones that are impacted due to this withholding occurrence. The love, affection, and emotional ties existing between the parties. It looks at the emotional bond. Him being prevented from seeing his kids is preventing him to continue that emotional bond and nurture that emotional bond, which he had prior to this latest withholding that has started back on December 27th. Factor B, the capacity and disposition of the parties involved to give the child love and affection. That focuses on the ability to, again, parent to foster an emotional bond in the future. He's having a hard enough time in the present, again, because she's not keeping in compliance with the court order, and he's not able to see these girls to be able to have a solid relationship and foster that relationship. the length of time they've lived in a stable, satisfactory environment, I'd submit to the court. Defendant's home is not stable, considering the allegations she's made that have been investigated by CPS twice, police twice, and both been denied. Nothing's come of it. Which leads me also to the moral fitness of the parties involved, which ties into the same factor. We have to keep in mind, Your Honor, at the beginning of this case, he was charged with domestic violence in relation to her essentially going after him to get keys to his truck so she could get some pot and smoke it. As he's being arrested, she's telling him, I want you to come home. He, of course, gets him on bond. He can't have any contact. Once the bond conditions get lifted, she's contacting him through text and saying, hey, let's meet you and the girls get together and we can go to the zoo or we can go to a park.
Okay, Mr. Kelly, how does this relate to your motion?
It's related to, Your Honor, again, the moral fitness involved, as well as the stable, satisfactory environment, in that she's accusing him of sex with girls. But before all this, she's wanting him to come home. She's wanting a relationship with him. She's wanting her family essentially reunified. Those two things don't jive together, Your Honor. And I would think that essentially it's a fabrication, which would go again to the moral fitness and also to the mental and physical health of the parties, Your Honor. You're making these allegations, these terrible allegations, but on the other hand, you're still wanting the same guy who's supposedly doing this stuff to come into your house. Finally, Your Honor, the unwillingness and ability to facilitate and encourage a relationship. Again, this is the fourth motion we're here this morning on, Your Honor, for him to see his girls. She doesn't follow your court orders. She withholds them for no valid reason. And she's clearly shown she's not gonna facilitate a relationship between him and his kids. I think that's more than enough that gets us over the threshold of a change in circumstance or a proper cause, because these things are having a significant impact on these girls' lives in terms of having a relationship with their mother. So we would request, as part of our relief, that you set this matter for an evidentiary hearing. We're also requesting during the interim that my client get temporary parenting time starting today, and that he continue to have them until the evidentiary hearing. That mom's parenting time be supervised at her expense, because she's clearly shown an unwillingness to follow your rulings or to comply with your court orders. I think if you don't do that, she's going to take these kids and run, and we're going to be in a bigger mess than we are today.
Okay, thank you. Ms. Couch, if you wish to speak to the motion.
I had some statements, but it's just what I had submitted to the court.
Wow. Okay. So Mr. Kelly just absolutely dismantled this woman's position piece by piece. And I want to highlight the most devastating part of his argument because I think some people might have missed it. He pointed out that this mother made horrific allegations against the father, the kind of allegations that could destroy a person's life. But before she made those allegations, she was texting him saying, hey, let's go to the zoo together as a family. Come home. Think about that for a second. You don't invite someone you genuinely believe is dangerous to come back into your home and spend time with your children at the zoo. That contradiction alone is absolutely damning to her credibility. And here's the legal significance. The attorney walked through the Michigan child custody factors, also known as the best interest factors, and he connected every single one back to her pattern of withholding. He's not just arguing for make-up parenting time anymore. He's arguing for a complete change of custody. He's saying give the father primary custody and make the mother's time supervised. That is a massive shift. And the fact that this is the fourth time they've had to come to court over this, that's the kind of pattern that makes judges take drastic action. Now let's hear what Karen has to say in her defense. Asterisk.
Okay, go ahead, tell me, and then
Okay. Would you like me to stand?
whatever you wish. If it's more comfortable sitting, go ahead, but speak up a little. So we can-
Okay. I said that his first statement was true, but the second statement that he said was false. I said I previously tried to change parenting time because of the videos the plaintiff had been watching. It was reported to Penfield's police department because plaintiff was previously residing in Penfield. I spoke to their sheriff where we looked at the videos together and he told me that he would be conducting a search and not to address the matter to the plaintiff because he would need time to get 2 search warrants and the investigation was never done. False. CPS is not taking the proper steps to ensure the minor children's safety, and I did mention police involvement in the last hearing as well. The 5th statement is also false. Errors were made by the plaintiff's attorney. The 6th statement is also false. There is supposed to be a pending CPS case, and I was never told otherwise. CPS and I have spoken on numerous occasions and decided that the best course of action was therapy, which the minor children are attending at Summit Point. I do have proof of all of that as well. 7, that's also false. I was never told that they were declining to investigate the police. Number 8, it's false. In early 2024, my mom threatened to call CPS on me because of the children's odd behavior, requesting that I get them checked by the doctor. I had the doctor examine them at their 2-year checkup, and almost 2 months later, the plaintiff was arrested for domestic violence. I originally withheld the kids because of the plaintiff's sexual preference for diapers and enemas, knowing that the plaintiff was not mentally stable enough for unsupervised visitation. The 9th statement is true. The 11th statement is false. The 12th, I'm unsure of the plaintiff's employment, but the plaintiff has stopped paying child support and I still stay at home with my children. Number 13, I have lived at the residence that the FOC has on file since December 10th, 2024. The 14th, statement, I'm unsure of the plaintiff's relationship status. I have friends and family in Michigan, and I lived in Indiana until I was 18, and most of my family resides there. Number 15, I would like the court to consider changing the current custody orders and issue no further contact between the minor children and the plaintiff. Plaintiff should be held accountable for his actions regardless of stature or representation.
Okay, let's talk about what just happened, because that was genuinely painful to listen to. This woman's entire defense strategy was essentially reading off a list going false, 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 also false, with absolutely no evidence to back up any of her counterclaims. She mentioned CPS reports, police investigations, therapy records from Summit Point. But did she bring A and Y of those documents to court? Did she bring a single witness to corroborate her story? No. She showed up to a legal proceeding with nothing but her word. Against a mountain of court orders she's already admitted to violating. And here's what really stood out to me. She asked the court to issue no side, further contact between the children and their father. She wants this man completely erased from his daughter's lives. That is an extraordinary request, and to make it without a shred of substantiated evidence after CPS and police have already investigated and found nothing. That tells you everything you need to know about her mindset. She genuinely believes she can override the entire court system through sheer stubbornness. Now let me ask you this. Do you think the judge is buying any of this? Drop your thoughts in the comments below, because this is about to get very real very fast. Asterisk.
I don't need anything else, Mr. Kelly. What the court will do in this matter is the court has read the pleadings, obviously you're well aware of the file in this case. The court does believe that the plaintiff has met the VARCA threshold of proper cause, change of circumstances sufficient for an evidentiary hearing. So the court will schedule an evidentiary hearing in this matter. Mr. Kelly, you can proceed with your show cause hearing. Do you wish to take testimony from your client? Okay, Mr. Connolly, if you step forward, we'll have you sworn in and then we'll take some testimony. And I say brief testimony, I don't need to get into.
Sure, we'll keep it straight and to the point here. Have you been getting your parenting time?
No,
Why not?
because she is refusing to let me see them.
Have you attempted to get your children from this couch?
Yes,
Have you called the police for their assistance?
yes.
What happened when the police got involved?
That she slammed the door in their face, denies them, and just tells them no.
Have you filed motions with the court to get parenting time?
Yes,
Has the court awarded you make up parenting time?
yes,
Most recently, did the court award you parenting time in January of this year?
yes,
Did you attempt to go pick the children up for that make up parenting time?
yes.
What happened?
She refused to give them to me again.
Do you approximately know how many days you have missed so far as simply your overnights for parenting time?
20.
Would you like the court to grant you some make up parenting time this morning?
Yes.
No further questions, Your Honor.
Okay. Ms. Couch, do you have any questions for the plaintiff? No?
You know, Mr. Connolly,
He is my son,
you heard him just testify that he has parenting time with your granddaughters, correct?
correct?
Okay. Do you assist him in pickup and drop offs for
I
parenting
do.
time? Has there been occasions when you have gone with him to go get the girls and anything happened in regards to him actually getting the girls?
Prior to December 27th, yes. After December 27th, no, she refused.
Let's talk about prior to December 27th. What would happen?
We would go, then we were meeting at Riverside Park and
Did you catch that? Did you catch what just happened? The attorney asked the father a series of devastating questions. Have you been getting your parenting time? No. Has she refused? Yes. Did she slam the door on police? Yes. And then the attorney turned to Karen and said, "Do you have any questions for the plaintiff?" And she said no, she had absolutely nothing to challenge, nothing to dispute, nothing to cross. And the judge immediately seized on that, saying, and I'm paraphrasing here, well, if you're not going to dispute his testimony, then I guess the court can accept it as fact. That is huge from a legal standpoint. In a show cause hearing, the burden is on the person accused of contempt to show why they shouldn't be held in contempt. She had every opportunity right there to poke holes in his testimony, to challenge his version of events, and she just passed. She gave the judge absolutely no reason to doubt anything the father said. This woman is building her own prison cell brick by brick, and she doesn't even realize it. Now watch what happens when the grandmother takes the stand and corroborates everything.
we would wait for her to show up. When she'd show up, she'd let the girls out and they would come running up to Zach and we would take them.
Okay. Did something change after December 27th?
She just started refusing to give the give the girls his first visit that he was supposed to was I'm not sure, but I got a text from Athena on New Year's Day saying
Okay.
that she was going to refuse to give the girls. Either she would not be home, he would text her and she would not respond, or if she was there, we'd knock on the door, she'd open the door and then just say no and slam the door in our face. So we would go back to the truck and call the police for the police to come out and assist.
And the police came out and assisted that help in terms of actually getting parenting time to occur.
No, she just did the same thing to the police.
Just to clarify, that he talked about prior to the December 27th date, and the court had previously entered an order which provided for makeup parenting time, that stated that the parenting time would again, the makeup would occur on January 27, 2025. And the plaintiff's motion states that he did appear on that date. Did you go with him on the January 27th date?
Yeah.
Okay. And what happened on that date?
She just refused. I don't know, either she refused or she wasn't there.
And you don't remember if she was not there or if she refused?
I don't remember that specific time.
Okay.
I have it written down at home, but I don't remember.
Okay. Ms. Couch, do you have any
I
questions
do,
of this witness?
yes. At what age did Zach Conley start wearing diapers?
Ma'am, what we'll do is we're here to determine whether there was parenting time. That's the show cause. Okay. So that's what the purpose of this hearing is. So you can ask questions about the parenting time, compliance with the orders, etc. Okay,
Okay.
go ahead.
And you were at my residence on the 27th to pick up the children?
Oh, actually, on the January 27th?
Yes. Or
Yes.
December 27th. Or sorry, no, January 27th. I don't have anything written down.
Yes.
Okay. Even though the order was for the 29th. Wasn't that the part
Whatever,
that the judge put
whatever
in
day,
place?
whatever judgment day.
So
I
you
don't know
just,
specific dates, whatever.
and I slammed the door in your face how many times?
Twice that I went by myself once because that was at an appointment that
And,
you slammed the door in my face. I have it on video, yes.
and you came alone, correct?
I did that day,
Okay.
yes.
That was all I have. I'm sorry.
Okay, Mr. Kelly, any redirect?
No, Your Honor, no further questions, no further witnesses.
Okay, you may step down then. Thank you. Ms. Couch, do you wish to present any testimony or witnesses? No? Okay. Check that order because there was some, Ms. Couch, you raised some issues concerning the I think it was the order of January 27th. I want to make sure if that was the time as well for the makeup parenting time. I believe it was, but
It was January 27th through February 9th.
okay, that's what I thought. And
I could have swore the pickup date was the 29th. I apologize.
well, I want to make sure that it's correct so that there's no issue.
But I was not home at the time of pickups.
I cannot believe what we just witnessed. This woman had the opportunity to cross-examine the grandmother, the one witness corroborating the HL father's testimony, and what was her first and most pressing question. At what age did Zach start wearing diapers? I'm sorry, what? The attorney immediately objected. The judge shut it down as not germane, which is legal speak for that, has absolutely nothing to do with what we're here for. And honestly, even the grandmother's response was pure gold. I would assume sometime after birth. Incredible. But here's the part that should really concern Karen. During her cross-examination, she literally confirmed the father's testimony herself. She asked the grandmother, "And I slammed the door in your face how many times?" She didn't deny slamming the door. She asked how many times she did it. She essentially confessed on the record to the exact behavior she's being held in contempt for. You can't make this stuff up, folks. Her own cross-examination became additional evidence against her. If you were her attorney, and thank goodness she doesn't have one because no lawyer would let this happen, you would be absolutely face-palming right now.
And why is that?
Because he is our children, and I don't believe that he needs any more parenting time.
Okay. You understand that there's an order for parenting time.
And if it was your children, you would be sending them with him.
I'm just asking you a question. You understand that it was parenting, that it was ordered.
Didn't you deny that? Didn't you go on base and deny it after the fact?
Not the other particular orders. I did deny an ex parte order at one point, but there were subsequent orders to that. Anything that was filed has been in the file.
I would love you to take that into consideration.
I would know for the court, I received no response to either of these pleadings for today's hearing.
Okay.
You got two in the mail.
Okay, the order is dated February 4, 2025. And it provided for makeup parenting time in Christmas Eve, Christmas Day, 2025. It also provided that the plaintiff would have the children with him on January 29th, 2025 at 6:00 p.m. until February 9th, 2025.
I have another question to ask you, sir.
Okay, let me clarify that because this is the order date.
Okay, this is the moment right here. This is where the entire case cracks wide open, and I need you to understand the weight of what just happened. The judge asked her point blank, "You understand there's an order for parenting time, right?" And she looked at Judge in the face and essentially said, "I don't care. I don't believe he deserves parenting time." She didn't deny violating the order. She didn't claim she didn't know about it. She didn't offer an excuse about being sick or having car trouble. She flat out told the judge that she made a conscious, deliberate decision to ignore his ruling because she decided the father doesn't deserve to see his children. That is textbook contempt of court, ladies and gentlemen. And then the judge dropped a line that was so perfectly measured it deserves to be framed. He told her that if subsequent orders were entered after a denied ex parte order, those new orders are to be followed, period. He's telling her in the clearest possible terms that she does not get to be the judge, the jury, and the executioner in this situation. The court system exists for a reason. You don't get to overrule it because you feel like it. And you can hear in his voice, he is done. The patience has officially run out. What comes next is going to be devastating for this woman, and honestly, she brought every bit of it on herself.
February 4th. Did you provide parenting time on the January 29th?
No, I did not.
Okay. And we had at the last hearing, and addressed the issue of the CPS involvement. CPS, as Mr. Kelly has stated, has been involved twice before, and they've not had anything substantiated. Is that your understanding?
No, I have the CPS report right here, as well as Carla Titus's number. Now she said that her findings weren't. I need to take the kids to therapy, to get the whole picture, from the kids, them talking, them playing, them, interacting with the therapist. And so that way they can go, they can go on record. And they are in therapy at Summit Point. Now this has just started, but they've already, said some things. That was one of my questions. Do you have the report from Summit Point? They told me that I needed to sign a release so that way they could contact you.
Okay, I'm not aware of any report from Summit Point. It may be in the file, it may not, but you've not introduced that today. And you don't have anyone that could speak to that from Summit Point as a witness in this case, which is what today's date is set for in this particular matter. So,
As the court's already touched on a little bit, this is our fourth motion to try to get him parenting time. We simply want him to have his parenting time, with the threshold being met, Your Honor, and considering the behaviors, and I think it's going to be ongoing from this couch. We request that the children be turned over to him today, that he have custody and parenting time with the children until the evidentiary hearing occurs. We request mom's parenting time be supervised. We'd also request the assistance of law enforcement to pick the children up. I believe they're probably with her mother, who's likely going to take the same stance as Ms. Couch and refuse to turn them over. Maybe give them the authority with a court order if she fails to do so, that she can be arrested. And in the meantime, Your Honor, we'd request a finding of contempt. Sanctions are doing nothing. You've sanctioned her $1,000, which she's a voice she's never going to pay. Doesn't have any impact on her. At this point in time, we request jail time, 30 days of jail time. Maybe that'll get her attention that she needs to follow your orders. Thank you.
Thank you. Ms. Couch, your closing argument.
I am acting in the.
And right there, the judge just gave her a masterclass in how courts actually work, whether she was listening or not. She keeps referencing CPS reports, therapy sessions at Summit Point, conversations she's had with investigators, but she brought none of it into this courtroom as actual evidence. She didn't file responses to the pleadings. She didn't subpoena the therapist from Summit Point to testify. She didn't bring a single document that was properly introduced into evidence. She's standing in front of a judge waving around, claims like they're magic shields, and the judge is telling her, "I can't consider what you didn't bring me." This is such a critical lesson for anyone watching who might ever find themselves in a custody dispute. The court can only rule on what is properly before it. Your feelings, your beliefs, your conversations in parking lots, none of that matters, unless it's presented as admissible evidence in the courtroom. Karen treated this hearing like a casual conversation where she could just say things and the judge would believe her. That's not how the law works, and now she's about to find out exactly what happens when you come to court with empty hands and a head full of excuses. Let me ask you guys at this point, do you think 30 days in jail is enough for someone who's violated for separate court orders? Let me know in the comments.
February 4th. Did you provide parenting time on the January 29th?
No, I did not.
Okay. And we had at the last hearing, and and addressed the issue of the CPS involvement. CPS, as Mr. Kelly has stated, has been involved twice before, and they've not had anything substantiated. Is that your understanding?
No, I have the CPS report right here, as well as Carla Titus's number. Now she said that her findings weren't. I need to take the kids to therapy, to get the whole picture, from the kids, them talking, them playing, them, interacting with the therapist. And so that way they can go, they can go on record. And they are in therapy at Summit Point. Now this has just started, but they've already, said some things. That was one of my questions. Do you have the report from Summit Point? They told me that I needed to sign a release so that way they could contact you.
Okay, I'm not aware of any report from Summit Point. It may be in the file, it may not.
The contrast in those two closing arguments could not be more stark. On one side, you have Mr. Kelly delivering a precise, detailed, legally grounded closing, requesting custody transfer, supervised visitation for the mother, law enforcement assistance, a contempt finding, and 30 days of jail time. He laid out specific remedies tied to specific violations. That's what a prepared legal argument looks like. And on the other side, Karen's entire closing argument was, and I quote, "I just want my kids to be safe. That's all. That's it. That was the whole thing. No evidence, no legal argument, no acknowledgement of the 4 court orders she's violated, no explanation for why CPS found nothing, no explanation for why police found nothing. Just a vague emotional appeal with no substance behind it. And look, I want to be clear. If there were genuine safety concerns, any reasonable person would understand a parent's desire to protect their children. But when every single agency tasked with investigating those concerns has come back and said there's nothing there, at some point, you have to accept the findings or bring better evidence. She did neither. Now, the judge is about to deliver his ruling. And folks, this is the moment we've all been waiting for.
Previously been ordered to make up parenting time as well as pay attorney fees, as I stated, and she's failed to comply with any and all of these prior orders of the court. Her recourse is to file motions, have hearings in the event that there is some issue. The court will note that I am recalling from the last hearing where she had made allegations concerning the plaintiff, and in fact, she acknowledged at that time that there had been 2 CPS involvements and the CPS had not done anything as a result. She acknowledged that she had been in contact with the police, that they had not done anything as a result either. The court will find that she is in fact in contempt of court. The court will, as the plaintiff stated, he's entitled to 20 days of makeup parenting time, and that shall occur at such time as he acquires the care of the children. The court will note that, again, the prior rulings of this court, that she had done makeup parenting time on 2 occasions, as well as paying the attorney fees, that in fact she has ignored and refused to comply with those particular orders. So, ma'am, unfortunately, you leave me no choice but.
Here it comes, folks. The judge is reading off her violations like a rap sheet, and every single one is landing like a hammer blow. June 13th, 2024, violated. December 2nd, 2024, violated. November 1st, 2024, violated. February 4th, 2025, violated. That is 4 separate court orders spanning nearly a year, and she hasn't complied with a single one. Not one. And did you catch what she just did? The judge was in the middle of delivering his ruling, the part where you sit quietly and listen, and she interrupted him. She blurted out, "But there's reason, sir. There is valid reason." Remember at the very beginning of this hearing, what did the judge say? He said, "Don't interrupt anyone. You'll have your opportunity to speak." She had her opportunity. She used it to say, "I just want my kids to be safe." And now, as the judge is about to sentence her, now she wants to talk. The judge shut that down immediately. "Ma'am, you're done." Ice cold and completely justified. She had every chance to present her case. She squandered it, and now it's time to face the consequences. The sentence is coming, and based on 4 violations, previous contempt findings, and unpaid attorney fees, this is not going to be pretty. Asterisk.
The court will sentence you to 30 days in jail with the Calhoun County Sheriff. The court will further remand you to the care of the Calhoun County Sheriff, where you will remain until such time as the children are turned over to the plaintiff and until...
And there it is. She just could not help herself. The judge told her to go with the sheriff. And instead of walking out quietly and calling an attorney to figure out her next steps, like a rational human being would do, she decided to start cursing and making vulgar comments in open court. And what did that earn her? Another 30 days for contempt. She walked into this courtroom today as a free woman, and she's now leaving with a 60-day jail sentence. 60 days, and the judge's response was absolutely legendary. Keep going. I can go as long as you. Wanty was literally daring her to keep running her mouth so he could keep stacking charges. That is a judge who has been pushed to his absolute limit by months of defiance, and he was not bluffing for even a second. You could see it in his demeanor. Every word out of her mouth was another day added to her sentence in his mind. And look at the father's family in the background after months of being denied access to those little girls, after 4 motions, after police calls that went nowhere, after doors slammed in their faces. They are finally seeing accountability. That moment right there, that's what justice looks like. So let's recap this incredible case and talk about what we just witnessed here today. A mother, identified in court as Miss Couch, was brought before a Calhoun County judge on a show cause hearing for contempt of court after repeatedly and deliberately denying the father of her children his court-ordered parenting time. The evidence presented was overwhelming and, remarkably, largely undisputed by the defendant herself. She violated 4 separate court orders dating from June 2024 through February 2025. She admitted to denying parenting time. She confirmed slamming the door on both the father and police officers. She refused to turn over the children even after makeup parenting time was specifically ordered by the court. Her defense rested entirely on unsubstantiated allegations that had been investigated by both CPS and law enforcement on multiple occasions. With nothing ever being found, the judge found her in contempt of court, sentenced her to 30 days in the Calhoun County Jail, ordered her to remain incarcerated until the children were turned over to the father for his 20 days of makeup parenting time, and required her to pay $1,000 in previously ordered attorney fees before her release. The court also granted an evidentiary hearing on the father's motion for a change of custody, signaling that a more permanent shift in the custody arrangement may be on the horizon. And then, in a truly stunning display of courtroom self-destruction, the defendant chose to make vulgar, disrespectful remarks to the judge on her way out, earning herself an additional 30 days, bringing her total sentence to 60 days in jail. This case serves as a powerful reminder that court orders are not optional. You may disagree with a ruling, you may believe you know better, but the legal system provides proper channels for addressing those concerns, filing motions, presenting evidence, appealing decisions. What you cannot do is simply decide your own that the rules don't apply to you. And when a judge gives you 4 chances to correct course and you spit in the face of every single one, don't be surprised when the consequences finally catch up. If you found this case as shocking